Welcome to Let's Talk Property, and hope that you're going to enjoy the new show. We've had some massive changes, and I suppose the biggest change is that you're seeing me instead of Derek Watts. Derek is stuck out on filming today, so he won't be able to join us, but as his stunt double, I hope to be able to do a good job, and hopefully I'll be able to do him proud, and hopefully Derek is somewhere watching to make sure that he's giving me some guidance in my ear when I need it. So just to go quickly into where we are for Let's Talk Property. Let's Talk Property has gone through a bit of a change. As you may have seen, we were off air for last week. We have joined with Real Estate Investor, and what we are doing right now is we have amalgamated, and we are running every alternative week for the webinars that we are going to be putting on. 1 week it will be done from the Elan office, and 1 week from the Real Estate Investor magazine. As I'm sure you're all aware, we're living in strange times. So if my dogs and the people cutting the trees in the background get in the way, we do apologize, and I'm sure it's going to be a good, healthy conversation today, but hopefully we can get the noises in the background taken care of. Just if we move across to the webinar itself, there is a little chat thing at the bottom, and please feel free to drop some comments onto that chat that we can hand across to the panelists. There is also a Q&A, and if you can just drop your questions into that, we'll answer it straight away from our side. Moving across to today's topic and introducing a very esteemed panel around the room here. I haven't had the chance of dealing with any of them before, but we had a little bit of a chat yesterday and this morning, so I was getting some massive insight into the rental market in South Africa, specifically from a residential point of view, and I'm here to learn a huge amount as we go through the day. But what we are looking today is we're looking at the impact of COVID on the residential rental market in South Africa, how it's affected us, how it's affected the people that are renting in the space, the owners and the physical people renting. So hopefully we can get some good insights. So what I'm going to do is I'm going to just introduce the panel very quickly so we can get a feeling for who we're going to be speaking to today.
Yes, good morning, everybody. My name's Simon Dippenaar. I'm an attorney. I'm the founder and managing partner of my own practice with the name Simon Dippenaar and Associates, or ST Law for short. We have a department that specializes in eviction matters, and we assist landlords and tenants with the eviction process. Our motto as a law firm is respect, recognition, and ethical responsibility, and I hope that shines through in all of our dealings. Thank you.
I'm sure we're going to get a lot of questions from the audience, and I look forward to engage with you further on that. I'm going to move across to Simon. I mean, I think, Simon, the role that you're going to play today really is going to be the person who's going to give us a huge amount of insight. There's been a massive amount of questions that have been posed in the rental space. And I think really what we're looking at is the inability to pay and the inability to get full salaries over this period of time. It has had a massive effect on the market, and obviously from an owner and a tenant that's inside one of these rentals, there's a number of rules that we should be engaging. We're speaking about this thing called Ubuntu, and there's a huge amount of space and change that we probably need to get used to. So if I had to direct that as a question, how has the legal field changed, and how has it adapted around what has happened for COVID? Because it wasn't something we could plan for.
Indeed. Look, there's a lot of fear and uncertainty in this context. Lawyers are supposed to bring certainty through the application of laws and rules. With the regulations changing and the various phases of lockdown, the law is in a state of flux, and it's not always easy to be absolutely certain about what to do. But the general principle that most lawyers and experts are trying to get behind is an attitude of sort of commercial Ubuntu, where contracting parties sit down around the proverbial table and engage each other with a sense of empathy, leniency, understanding, let's say emotional intelligence, which is something that isn't always found in commercial contracts. Although we live in a constitutional democracy, and the constitution itself has made its way into commercial contracts as the law has developed. But it's even more important now in the lockdown period for lawyers, landlords, and tenants, parties to contracts, to understand that there is a social humanitarian concern that needs to be built into the enforcement or creation of contracts in this context. So if you're in a situation where you can't fulfill your obligations in terms of a lease contract, which is obviously the relevant contract in the property sector here, it's important that you engage in a mediation type of setup with all parties. Pursue these alternative dispute resolution avenues before sending strict letters of demand. Assert boundaries in that way so that you don't isolate yourself from arguable vulnerable parties. You may be vulnerable yourself as well. I mean, there is this knock-on effect. It's not only a tenant that can't pay rent, it's a landlord that may not be able to cover his bonds. So it really is a community issue where all the role players along the chain need to buy into this sort of sense of, as I said, commercial Ubuntu or mediation or alternative dispute resolution avenues. But it's also not a time for parties to take advantage of each other. It's good to engage the services of someone that is not emotionally involved in the resolution of the contract equation or any breaches of contract. I would recommend that a good managing agent or an attorney that specializes in mediation, property law, eviction law, or collections get involved from the beginning. There are wonderful agencies such as TPN also that have provided some real practical legal solutions to tenants and landlords. I'll leave that to my colleague Michelle to go through that. But very briefly, they've provided for free online certain contracts that allow certain indulgences and extensions to contractual obligations in the form of rental deferment contracts and deposit utilization contracts. And I'll leave that to Michelle to elaborate on that. But as an attorney who supports mediation and these kind of extensions, there are some interesting tools that parties can utilize, as long as the big institutions all come to the party. Sorry, go ahead.
So if I can put you on the spot there, and I buy the fact that you prefer the mediation, but can somebody be evicted over this period of time?
Yes, good question. So I would say evictions are a very delicate topic at this point in time. It's always been a bit of a pejorative legal term. No one really wants to be called an eviction attorney per se. It's almost like being a criminal attorney, that people think that you're keeping guilty people off of the streets. But an eviction attorney isn't only interested in evicting people out onto the street. An eviction attorney follows a process. And we've had some very smart, very competent lawmakers that have created the PI Act, the Prevention of Illegal Eviction Act, which contains the general process of eviction. And the process of eviction really is about ensuring that a person is evicted from a home in a just and equitable way, while balancing the various opposing interests in the most fair way possible. So you've got the landlord that wants to use and enjoy his property, maybe make money from the property, and you've got the tenant that also wants to use the property as a temporary home and the limited conditions as contained in the lease. But if they can't pay rent, or if they can't afford to pay, they are in breach, and the landlord has followed a proper process, a mediation process, let's say, and then the legal process, if that's just ultimately the last option available. They can continue with the eviction in lockdown, but lockdown level 3, as it stands, eviction orders are paused, are held in abeyance until the phasing down of the lockdown level 3 to what it seems to be the lockdown level 2 at this stage. We'll have to wait to see what the regulations say. But there is a caveat to that. In terms of the regulations of level 3, if a judge feels that it is just and equitable for somebody to be forcibly removed by court order, they can make that order. I haven't seen it happen. It's just there for exceptional circumstances. I can imagine, let's say, if there's an urgent eviction, if the home is about to be burnt down, let's say, or you've got a nightmare tenant that really has been a problem even before the COVID-19 circumstances, and it would just their continued occupation of the property would render the landlord in an untenable economic, financial, or legal circumstance.
I think that's for my last question for you for now. The lost revenue or the lost payments that are not received over this period of time, are they effectively lost because of what's happened, or is there a degree of recovery, or is that all based on the consultation that the tenant has with the landlord?
Well, look, if they haven't been paid and they haven't relinquished their right to collect, the same legal options are available to a landlord to enforce the collection of a rear rental or damages to the property if they do an ingoing, outgoing inspection under these circumstances, and even a holding over claim, which is basically a legal claim to sue for the damages that the landlord suffers as a result of not being able to rent the property out because of the tenant's continued unlawful occupation. So one could issue a summons and keep a court order for a rear rental and other damages, and then perhaps execute it against any assets or attach any salary in the future. That order exists for 30 years. I would probably recommend, if a landlord can afford to hold it over, and I use that term loosely, I would recommend that they do so, just to strike the right balance that would be required given what's just and what's fair and equitable given COVID.
There's no doubt it's difficult to navigate through, and I don't envy what you have to do. And Simon, there's a lot of questions coming through, and obviously a lot of them are based on the legal side. One of the questions that have come across now is if the protocol that's been set out is not followed by both the landlord and or the landlord itself, the protocols are not followed in the eviction, what is the recourse that the tenant has? And you're on mute there, Simon.
My apologies. Yes, so protocol procedure is the name of the game when it comes to the assertion of legal boundaries in the context of eviction and property law. If a landlord doesn't follow a proper pre-court procedure or protocol or a court procedure, then he's going to encounter some difficulties when he gets to court, when he gets to the eviction hearing in front of the judge. The technical process has to be pursued 100% correctly for a judge to be in a position to grant an eviction order or to make an order for damages against a defaulter. So essentially what I'd like to make the viewers aware of, in terms of the eviction protocol or eviction procedure, it's really important for a pre-court notification process to be followed perfectly. And that essentially is letters of demand, or otherwise known as legal notifications, that need to be sent to the tenant under certain circumstances. Generally speaking, if a tenant doesn't pay, a landlord has to notify them in writing and serve this written notice to them at the property, usually at the leased property by registered post. The lease may have different requirements when it comes to the particular procedure as outlined by that lease, but these are our general principles. And ultimately, the Consumer Protection Act might apply or not, but in general, you need to give about a 20 business day notice period to a defaulting tenant to pay or to rectify any breach. This is just the general scenario. And if they don't fit, a landlord's entitled to cancel by sending another notice of cancellation, as it can be termed. So if, for example, a landlord doesn't follow the Consumer Protection Act by giving the proper days to rectify a breach and just goes straight to cancellation and proceeds to court, the court application is technically flawed. And if he ends up going through the whole PI procedure to get the court hearing, which normally takes about 6 to 8 weeks to get to that hearing stage, a judge is going to throw the application out, and the eviction attorney who assisted him is going to get into a lot of trouble, and they're going to have to restart the process. So the procedure is designed in order to create a sense of fairness and equity into the process for a tenant, because a tenant is exercising a constitutional right to adequate housing. If they're using the property as their only home, they are exercising that fundamental constitutional right. And one can only infringe upon that right in a justified way. And you do that by following the technical procedure or the protocol, as you mentioned.
Well, thank you. Look, I mean, based on the questions coming through at the moment, you are obviously very, very busy in this space, and I'm going to come back to you with a few more. Okay. Going back to Simon. Simon, we've got a question here that's come through from Aju, and Aju's asked, what is the best legal structure one would recommend? If you're going to play in this game, what would you set it up? Would you set it up as a trust, a company? What advice or guidance could you give him?
Okay, that question is going to be beyond the scope of an eviction attorney per se. I think that is going to be best leveled to a commercial attorney that understands those juristic entities. There obviously are certain pros and cons of using the juristic persons, the companies, the trusts in terms of tax and risk mitigation, so that you can prevent yourself from being held personally liable. But that is the domain for a commercial specialist, if I could dodge that question.
Perfect. Of course you can. Over to you, Simon, if you can just give us your sort of parting knowledge and a little bit of insight. And if you can cover in one of your things, I've just got a question now, just on unopposed evictions, what those sort of costings would be. So if you could, in your wrap up, just sort of allude to some of that, please, that would be great.
All right, thank you for the opportunity, Eugene. Look, when it comes to evictions, the prices can vary depending on which law firm you use. Some law firms are specialists and they have economies of scale and systems to reach certain efficiencies. But look, the market price for evictions for the lower court or the high court, there are pros and cons to both. I prefer the high court because there's less risk of an appeal of an eviction order, which stalls the enforcement. An unopposed eviction matter, you're looking at about anywhere between 10 or 20,000 Rand for a fixed fee or flat fee for a high court unopposed eviction application. If it becomes opposed and there's certain delays, normally an hourly rate would apply. I'd be happy to supply some more information about our products and also the market value of that particular service. In terms of concluding remarks, I would say, look, as an attorney, it's my job to defend a client's legal position and assert their legal boundaries in the best possible way. COVID-19 requires us to assert ourselves more now in an emotionally intelligent fashion than ever before, because certain people are defaulting because of circumstances beyond their control. But at the same time, they do need to take responsibility. I would also, in closing, say that we need to avoid the Machiavellian approach to the resolution of legal equations and rather follow the Nelson Mandela approach. And ultimately, I think, don't try and do it yourself. Get a professional person like a managing agent, like an agency like TPN or a private law firm to assist you at arm's length, emotionally involved in the matter to help you resolve the matter. Excuse the cheesy metaphor, but you almost need a sort of a knight in shining armor, someone that is a gentleman or a lady that's got good morals and good values, but can also take out the proverbial sword to assert a boundary. Not necessarily decapitate, but assert a boundary.
Simon, thank you for your insight. You've really been helpful today, and I hope that the people take up your advice.